Supreme Court parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90 and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application and same is accordingly dismissed.
You are grateful to the court.
I am most grateful.
Yes, please may I have your attention. Indeed, we set today, we adjourn the matter to today for case management so that we can have the consensus from both parties and proceed to hear the petition. So we hear from you the issues which you think should be set down for. Try. Yes. Mr. Chikata, we want to we are seeking the assistance of both counsel to give all counsel in this case to give us some assistance in arriving at issues so that we can proceed to make consequential orders.
Well, my lords, before we get into that, I may say that we will urgently require a certified true copy of the ruling that you have just delivered so that we can advise ourselves in respect of that. And if we can have it by the end of the day, that would assist in the further processes that will take. Now, secondly, my lord, as I indicated right at the beginning, we have served a request to admit facts, which is a request we have served on the first respondent, and we have also served a request to inspect documents. Now, my lord, in respect of the request to admit facts, again, that is in the nature of a process of discovery, which also comes under CI 47, and we have the clear understanding that in respect of that also, the number of days within which we have indicated 3 days within our request to admit facts. Now, that is not an application before you at the moment. I recognize that. However, I'm drawing your attention, the attention of your lordships to it because that will also affect whatever other steps are being taken in respect of this case. So I think we recognize that you have just given a ruling about the operation of CI 47 and how it's affected by the subsequent CI, which we will advise ourselves on once we have it. And I think that that will guide the process of our recommendations in respect of the case management. The final thing I will say is that I think, as is fairly normal, we are quite happy to set down the issues that are arising from the petition and the respective answers and put that forward so that it is considered by counsel. I do not think that is a process that is easily done just on one's feet in a courtroom to try to determine what are the issues. I think that a normal process is perhaps for us as petitioners to put forward issues, and we are happy to undertake that with as much expedition as is consistent with the interests of justice. Yes, my lords, we would seek further direction from the court whether the court wants us to raise our issues now. We should file a process because we.
Sorry. A process in what form?
Well, that we
want you to file issues so that you settle on it. Maybe by tomorrow.
Well, my lord.
Mr. Kutampa. Yeah. Mr. Chikata.
My lord.
Yeah, please, can you oblige us so that if...
My lord, I think tomorrow is a stretch because, one, I don't think we can respectfully do it by tomorrow because, first of all, respectfully, we are going to advise ourselves in respect of the ruling you've just made. We are going to take that into consideration because your ruling, as we heard it, seems to relate to the operation of CI 47. And so, since these processes of issues, they are not provided for in CI 127, the CI 99. They are not provided for in CI 99. There is no specific, so again, normally we would be guided by what happens in CI 47. But that's why we need to understand your lordship's ruling, and once we get it, I think we will know what steps to take. But I think tomorrow it will not be possible for us to submit.
Try to be a bit flexible, because if you look at the operative rules, there is no provision for amendment. But we thought it is inherent in the court of law, to be very flexible, to allow amendments. But whatever it is, if tomorrow is not convenient to you, because we thought having settled the pleadings, at least you can unearth the issues, yes, by tomorrow, so that we set the what do you call it, the case management in motion. Yes.
If Thursday is acceptable, by Thursday we should be able to put.
Yes, Mr. Kutampa, excuse me, please.
My lords, today was set up for case management, and all lawyers know that case management involves determining the issues for trial. And all of us should have been prepared for that. It is not acceptable that any counsel may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues. That is highly unacceptable.
Please, so, it was overtaken by events because there was an application which had to be determined. Yes. And
my lords,
we adjourned, the court adjourns a matter. We adjourned it to today. For pre-trial.
Yes.
Case management.
Yes.
Then an application was filed.
Yes.
And we thought that it was prudent on the part of the court to take the application, and we've taken it. So if we adjourn it tomorrow, we hope that you can do us a favor and file the issues. Yes.
Very well.
Because we don't want to impose the issues on you, but ultimately it's the court which will have to consider the issues which parties have filed, so that we proceed on the common
my lords, if we can take a cue from the precedent of the 2013 petition, this matter of issues to be tried was determined in open court. So it seems to me that if your lordships are directing that we come tomorrow for that, we should come and read out our issues and for the court to take up the issues.
Okay.
Because filing these matters may take some further time.
If you prepare the one, you can read it at the registry. Sorry, if I read at the registry.
We are ready.
Very well.
We are ready. We are ready.
Unless we are just concerned that this matter be dealt with very expeditiously.
We are ready. We are ready.
My lords, I believe that I've indicated that it would not sacrifice expedition if we had until Thursday, because we also need access to a ruling that you've just delivered.
You have it, but
Yeah.
Let the issues for determination be filed by tomorrow before 9:30 a.m. The case is adjourned to 9:30 tomorrow a.m.
My lords, just for clarification, I believe that beyond the determination of the issues, all other issues of case management will be dealt with tomorrow. Yes, yes.
Rise.
You're live on Joy News today with me, Daniel Daze. So the key word you need to remember today is dismissed. That's right. Now, earlier, the lawyers for John Mahama wanted the Electoral Commission chairperson to answer some 12 questions including whether or not the National Communications Authority assisted in the transmission of results to the EC's headquarters. Now, the EC's lawyers, in their response, said that Mr. Chikata, who is lawyer for Mr. Mahama, was using the back door to introduce matters that were not stated in the petition. So they further argued that the other questions are not in contention and they have either been answered by the EC or it is information that John Mahama is well aware of because he deployed agents across the country. So as you heard earlier in the discussion with Mama V, the Supreme Court went on a short break to rule on the matter. That matter has been ruled upon. The application by John Mahama through his lawyers has been dismissed. Now, following that, there was a bit of drama because we did see that, first of all, Mr. Chikata, who is lawyer for John Mahama, said that his side would request a certified true copy of the ruling that the Supreme Court justices just delivered, and they would advise themselves. He used that expression repeatedly, that they would advise themselves. Now, remember, today was actually set aside for case management or pre-trial, where lawyers on both sides will lay out certain issues, and then those issues will be decided on. That has not started yet. It should have started today, as was pointed out by Akoto Ampao, lawyer for President Akufo-Addo. But as the Supreme Court justices pointed out to him, because of this application for interrogatories, which was, filed by John Mahama, that case management could not begin today. Now, Chikata also went on to say that there was a request to admit facts and to a request to inspect documents, which are all part of the process of discovery, according to CI 47. He did admit, though, that this is not an application before the court. It's a request to the EC and President Akufo-Addo's lawyers. Then he went on to say that the court then said that, fine, if that is the case, we've given our ruling, tomorrow let's continue with the case management. Mr. Chikata responded by saying that tomorrow may not be possible because they have to advise themselves on that application. But we've been joined on the phone by Joseph Akable, our court correspondent, who has been viewing this from within the Supreme Court. So, Joseph, walk us through that, the dismissal of the application by the Supreme Court. Walk us through exactly what happened. Did the Supreme Court justices, for instance, give any reasons for their decision? Right. Unfortunately, we seem to have lost Joseph Akable in there.
Well, the real work in court has started. All this propaganda of having won 2 goals to 0. This is the first application that has formally been moved before the court. The application for a televised broadcast had already become moot because the court had already set in place the procedures for a live telecast. The application for interrogatories was dismissed outright by a unanimous panel of 7. This tells you that the petitioner has a long way to go insofar as this petition is concerned. There are ground rules which have been set for this petition, and the Supreme Court is not going to allow for unnecessary and interminable delays in the hearing of this petition. We are gladdened by the fact that the opposition we mounted was exactly what was rendered by the Supreme Court in its ruling. We heard counsel for lawyer for a petitioner talking about time to have certified true copy of the ruling. Well, that is his right, but that would not delay the trial. The courts have indicated quite clearly that tomorrow morning we are here for the pre-trial. So tomorrow morning at 9:30 a.m. we will be here. Indeed, just to let you know that we were ready and prepared with our issues, because the last time the court directed that it was going to be a pre-trial, every lawyer knows that when the case is adjourned for pre-trial, or case management, you have to prepare your issues. And if you bring an application to court, you either know that the application will be granted or dismissed. So there is no need to wait for that to happen. Much more so when you filed your application just about 2:40 p.m. yesterday. What did you expect? So yes, the application has been dismissed. Whatever they do afterwards is their own business. But yes, the real case in court has now started.
Is your contention that they are delaying the process? We heard your colleague make that point that he wanted to be dealt with.
Well, what else could be further from the truth? We came to court when on the 14th. If indeed you wanted an application to be heard from the 14th that we came to court, we had an intervening period of a Friday. You wait until yesterday before you file the application for interrogatories. And even this morning, that was when they filed the request to produce documents. I mean, what at all can be the reason for that? You can answer. What at all can be the reason for that?
You suspect they are delaying?
I say, what at all can be the reason?
You tell me what you think, sir.
The court said that there should be expedition. The court said there should be expedition. So that answers your question. Okay? When the court has invited us to come for case trial and management, a pre-trial, it means that you have to have your issues before you come to court. Whether you have an application or not will depend on the ruling that the court gives. But that does not preclude you from coming to court with your issues. And that is exactly what they failed to do.
Thank you very much. Thank you. And that was Mr. Frank Davis.
So you're live on Joy News today. You heard there Mr. Frank Davis, a member of the legal team for the EC and President Akufo-Addo.